Welcome back. In today's feature, we take an early look at a wild courtroom moment straight out of Florida. A man tried to argue his case using the so-called private citizen approach, but the judge wasn't having it. With zero patience for disruptive tactics, the judge quickly shut him down and made it clear the court runs on law, not loopholes. Let's dive into the exchange.
State your name, sir.
Mr. Fox, before the court trial of possession of paraphernalia and a no valid driver's license. You understand the charges?
You understand what you're charged with?
No?
No.
No. He doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license, yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is.
No.
Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. This county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth
It's
about
not
it.
easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the
Nobody's
contract.
asking you to admit to anything. I just need to make sure you understand the charge.
I'm a private citizen, sir.
I'm shocked.
Under UCC focus.
Oh, UCC? Oh, I love it. A sovereign. Golly Moses, I love those.
Honestly, given his haircut, it wasn't all that shocking that he decided to represent himself in court. And like many who follow the sovereign citizen path, he carried the same disheveled look that seems to come standard with their arguments.
Mr. Fox, crap in one hand, hope in the other, and see if that helps. Bond said at 5,000 the meth, 1,000 paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right. So the team.
Mr. Fox, when you sue me, make sure you spell it with two N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that. Next.
The judge made it clear that he could be facing up to 30 years if convicted. So this really isn't the moment to make reckless choices. Accepting the free lawyer guarantee by the Constitution would be the smarter path forward.
All right. It's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on one second.
All right. Good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please tell me? Well,
I'm here physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent to that.
One day, I wouldn't be surprised if a study concludes that sovereign citizens are just ordinary people with some questionable habits that set them apart from the rest.
I didn't even consent to. I was gonna go there today, and you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you
All right.
file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds? Who
Mr.
issued them?
Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So,
So then what am I doing here then? Hold on, what am I doing here?
well, right now you are not responding to my questions. So
Well,
I'm
you're not
going to have you
responding to any of my. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything. I'm not
Then-
perfect.
At first, it almost seemed like he might actually know his way around the courtroom. But the moment he started speaking, that impression quickly disappeared.
come in person so that we can be sure that you understand what's
All
going on.
right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
It's almost amusing that someone convinced you felony drug charges could be solved with a simple bond filing. But the reality is far different. And that supposed get-out-of-jail-free plan isn't how the system works.
Ms. Sobe, you're here on the Martin matter, correct?
Yes, Judge.
Let's go have a conversation outside.
He'll be assistant. Okay, so everyone,
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
yes, good morning, Judge. Donna Silva on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I was making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I could adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements. You're talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything, and you keep doing all your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere. I don't know.
In the end, it makes no difference whether someone calls themselves a private citizen, a state national, or anything else. If they act like a sovereign citizen, that's exactly what they are.
You don't have the first clue when it comes to things, and you talk about that. And so Mr. Gazicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gizicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I want to state also that if it was recorded, we would say it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like, or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did. Well, I won't say for the most part. Maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
Bye. Have a great time.
That's certainly one way to lose the right to represent yourself. And with a court date already scheduled for mid-December, the judge took a moment to faintly remind him who holds the authority in that courtroom.
Okay, good afternoon. My name is David Heiss. I'm an attorney magistrate. We are scheduled for an informal hearing in two different cases that arise out of one citation. And those two cases are both entitled The People of the City of Battle Creek versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had two violations listed on it. So it became two different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay. All right.
I'm not sure why you're asking that, but that's okay.
I'm definitely looking forward to the next hearing. While the judge has ordered counsel for the defendant, it's unlikely this sovereign citizen will accept it without a fight, which means more courtroom drama ahead. Make sure to like, comment, and subscribe with notifications on so you don't miss what happens next.
I can tell you this. The Michigan motor vehicle laws, including the laws that require you to carry insurance, that require your vehicle to be registered, and require that registration to be current, do not run in violation of any right to travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus.